I'm Dr. Karin Huffer, and we are continuing our Unlocking Justice series. Today I have with me Don Allen Mo Frederick. I'm going to be calling him Mo because that's what I know him as. Attorney, certified ADA advocate, Americans with Disabilities Act advocate, and a facilitator at Phoenix University where he teaches students of various kinds, but mostly in business law.
Business law, criminal justice.
Business law, criminal justice at University of Phoenix. We're going to be talking about the questions I have been asked because, as you know, this series has to do with answering the many, many questions that came in after this book, Unlocking Justice, was published. I'm observing that same thing. In fact, I have a case right now that is heavy duty along those lines. She was tested more than 2 years ago. The person destroyed the raw data from the test, sent her out for treatment based upon her having narcissism, histrionic, and basically a sociopathic personality. Sent her out for treatment. She knew her treatment wasn't working, so she kept looking for someone that could really help her. She then was accused of not being able to get along with her counselors, but it was the wrong treatment. And like I keep saying in court, you don't treat a broken leg with chemotherapy. If you have the wrong diagnosis and you have the wrong treatment, it simply can't work. What we found out with her is she had PTSD, post-traumatic stress disorder. It's an injury, broken leg. You don't treat her as though she's mentally ill, which is what they were trying to do. So she got a wonderful psychologist who now has really recently, within the last 2 months, really gotten a good handle on her mental condition and the post-traumatic stress disorder. But the court is fighting it. They want to go with the old tests 2 and some years ago, which aren't valid anymore anyway. Like you said, when they go for these tests, it's a moment in time. That's all that's assessed. Then that comes back to the court and assumptions are made from that. Now, exciting, and if you remember from your training you took with me, exciting now is with the new Americans with Disabilities Act, we are now invited to look only at the person as to what are your functional impairments? How is your executive functionality impaired? And then how can we arrange accommodations to offset those impairments so you're a fully executive functioning person? I think that is such a more sensible way to go. Plus, think of the money it would save. You go through and the other thing I find, if I appoint you to do a job, I'm probably not terribly anxious to argue with your findings. I trust you, what you bring in, I'm going to say that's the word. I'm concerned about court appointees because if the judge appoints them, is the judge apt to say, no, I don't think this is right? I think they've ended up with a system where they kind of rubber stamp one another because they trust one another.
That's true.
And if one of them makes a mistake inadvertently, it's apt then to get rubber stamped all the way around.
I would agree with that, and I guess I would add to it as well. I don't know if I'm going to be directly on point with you, but something that crosses my mind is the absolute need for every professional in the legal system and very many other systems as well. We need to develop an ethical rule about identifying persons with disabilities. Whether we're on one side or the other, we really need to have some ethical rules out there about how to better treat people with disabilities. As you know, the ADA didn't come out until around 1990, and it's just one of the most recent marginalized groups that has ever received any recognition, and there's been so much growth since then. What we haven't done is I don't think we have addressed as thoroughly as possible ethical rules for attorneys around this issue, ethical rules around mental health professionals, guardian ad litems, judges, Granted, they would be a natural extension of attorneys and stuff, but we're still not recognizing this as a essential necessity in our courts yet. And
Yes.
so that is why, I think we're at the ground level still, and I think we need to develop more around actually holding people accountable for this very issue.
Holding people accountable is one of the issues that I hear a lot about with, like I said, we're here answering questions now, and many of the same question, and it's had to do with the same thing. What standards are they held to? My attorney, guardian ad litem, parent coordinator. I have children with 7 professionals involved in their lives and no mother. Mother's been removed and they've got a psychologist, minors counsel, all of these different roles that are played in family court. What I'm concerned about is I developed for the book a rubric which talked about the basic standard that has to be developed, and then I developed a standard of care.
Right.
Now, at my website, I will be sure that those are front and center somehow soon at the equalaccessadvocates.com. Everything I talk about here, if there's something that I think people will want to refer back to, I will have it posted on that website. And I will post the rubric and the standard of care chart. Because if we begin to really take a look at that and make changes, if you will, whoever needs to make changes. But what we need is to all agree on a standard of care. And every time I speak, I assume the professionals that have invited me to speak are consummate professionals, or they wouldn't be opening this door and attempting to serve persons with invisible disabilities.
Well, Dr. Huffer, I guess my only concern is I wouldn't use the word consummate.
That's a goal.
If we have reached that, then we're not going to be able to learn more.
Okay.
And so I guess I would think we
We're
need
becoming
and we need to have, as you would remember, we had a training in March of 2012 on trying to bring professionals to the table on this very issue, and you are our keynote speaker. Mm-hmm. And it's my understanding we might make some of those clips available on the website as well. But at the very least, we are at ground zero, and we have not been trained on this issue at all. If you think we're consummate, it's a natural fallacy to think that attorneys know it all, and that we can do every area of law, and very many of us may attempt to do that, and we're not attorneys for very long. But in all honesty, I can't express enough my frustration with the lack of education on this issue, and we are not preparing each other for this. So we're going to try to reach out to the Colorado Bar Association, the American Bar Association, the local bar associations, and even if it's a drop in the lake, we're going to keep making these ripples flow so that people understand this is a big deal. The federal government has taken it very seriously, and you have had many successful attempts through the federal system to correct the state system.
Yes.
And it's a shame that we have to go there. But the truth is, we need to bring the seriousness of this to light. We had an attorney here in Colorado Springs that was fined several tens of thousands of dollars because he wouldn't allow a potential client to come in with their guide dog. And maybe a person with obvious disabilities is accommodated more in this system. We need to be talking real seriously about persons with hidden disabilities as well, and making sure they're as accommodated as well.
Every person that goes to court has to have physical, participatory, and testimonial access. I'm attempting to meet the need of that training with my webinars. I hope it's effective enough. Next one, by the way, starts October 3rd of 2012. I'm trying to run these webinars so that for a reasonable price, we are barely scratching the surface on such training.